It seems there's still some people who are unclear as to what Bill C-16 has actually done in Canada. Everything that follows will be something that I've touched on before for one reason or another, but I want to put it all in one place in an attempt to be as comprehensive as possible. We're going to discuss pre-existing law, we're going to discuss the rules of the human rights tribunals, which in my province of Ontario are actually called social justice tribunals. We're going to discuss the bill itself, and the policies driving it through which the bill should be interpreted. Pour a drink, buckle up. This is going to be a long one. To get the full picture on C-16, there's a few things with which we'll have to familiarize ourselves. I think the best place to begin is criminal harassment. Section 264 of the Criminal Code, subsection 1 reads, "No person shall, without lawful authority and knowing that another person is harassed, or recklessly as to whether the other person is harassed, engage in conduct referred to in subsection 2 that causes that other person reasonably in all the circumstances to fear for their safety or the safety of anyone known to them." I wouldn't argue with that. I imagine few would. So let's look at prohibited conduct, subsection 2 of the same. Part B reads, repeatedly communicating with, either directly or indirectly, the other person or anyone known to them. Considering the previous caveat of a person reasonably fearing for their safety, that makes a kind of sense. You may or may not be familiar with the case of Gregory Allen Elliott, who was accused of criminal harassment by Stephanie Guthrie and two others whose names escape me at the moment. This was all based on what was, in effect, a Twitter flame war. The three women, for whatever reason, decided to block Elliot and then proceeded to talk shit about him over Twitter, which is a public forum. He found out about it, commented on the hashtag that they were using to, deride him, basically. And they charged him with criminal harassment. They wanted to create a situation in which they could publicly talk shit about him, but he could not publicly talk shit back. Now, ultimately, he was acquitted because he actually didn't do anything wrong. But that was after he was dragged through the courts for 3 years, during which time, if I'm not mistaken, he was not allowed access to the internet. He hadn't been convicted of a crime and was already being punished. I bring this up strictly to demonstrate that even a reasonable law like this can be abused. It may be notable that the punishment for criminal harassment, if convicted, could be imprisonment for a term not exceeding 10 years. So now it's time for everyone's favorite topic, hate speech. Sections 318 through 320 of the Criminal Code deal with hate propaganda. 318 has to do with genocide, 320 has to do with warrants for search and seizure, so we're going to focus on 319. Section 319, subsection 1, public incitement of hatred, reads, everyone who, by communicating statements in any public place, incites hatred against any identifiable group where such incitement is likely to lead to a breach of the peace is guilty of A, an indictable offense and is liable to imprisonment for a term not exceeding 2 years, or B, an offense punishable on summary conviction. Subsection 2 of the same, willful promotion of hatred, reads, everyone who, by communicating statements other than in private conversation, willfully promotes hatred against any identifiable group is guilty of A, an indictable offense and is liable to imprisonment for a term not exceeding 2 years, or B, an offense punishable on summary conviction. I find these two subsections interesting. Subsection 2 seems far more cut and dry to me, the willful promotion of hatred. It seems very clear that you know what you're saying, you mean to say it, and you want other people to think the way you think, to hate the way you hate. Subsection 1 is less clear. Inciting to hatred, first off, that's not really provable. Even if someone were to say, I watched Irving Twin's video, which is a statement in a public place, this is a public forum, YouTube, and that made me hate people with non-binary gender identities. They're just saying that. You can't really prove that that's what made them do it. Maybe they already hated them. Maybe there was something between watching my video and them deciding they hate people who claim to be non-binary. You can't track it. But let's take it a step further. Imagine somebody says, oh, I heard Irving Twin's YouTube video and his opinion that there's not enough evidence to convince him of the existence of non-binary gender identities, so I murdered this person who claimed to be non-binary. Am I on the hook for that now? That's a legitimate question. I'm honestly not sure. I mean, considering the Gregory Allen Elliott case, Stephanie Guthrie case, I think that's more than enough to at least charge me. I'm sure I'd be acquitted, but that could take years, apparently. And God knows what I'd have to go through during those years. Hate speech laws are retarded. Subsection 3, defenses, reads, no person shall be convicted of an offense under subsection 2, A, if he establishes that the statements communicated were true. Whew. Suddenly I feel better. Until we get to the part where we're reading the policies behind C-16. Then I'm going to feel much, much worse. So far, we've been examining the criminal code, but now we're going to take a look at the extrajudicial human rights tribunals. Similar from province to province, but the social justice tribunals of Ontario are the model for the federal human rights tribunals. So we're going to take a look at that. Rules of procedure. Under powers of the tribunal, we see the tribunal will determine how a matter will be dealt with and may use procedures other than traditional adjudicative or adversarial procedures. Traditional adjudicative or adversarial procedures are exactly what one thinks of when one thinks of a courtroom. You know, a prosecution, a defense. It's what you see in your average episode of Law and Order. It's where people have a right to due process, a right to a fair trial, and to face their accuser. Human rights tribunals, social justice tribunals, don't have to adhere to that. In order to provide for the fair, just, and expeditious resolution of any matter before it, the tribunal may limit the evidence or submissions on any issue. The tribunal can limit the defendant from submitting evidence at all. They can prevent you from mounting any kind of defense. Take any other action that the tribunal determines is appropriate. The tribunal can do whatever it wants, and you don't have any rights before them. This shit needs to be nuked. So far we've seen that the regular old criminal code can be abused. Hate propaganda laws are retarded, and the human rights tribunals are basically kangaroo courts. There's no way that C-16 could severely fuck the dog, right? I'm not going to read the bill in its entirety. I'll leave it up long enough that you can pause it and read it yourself. But basically, it amends the Canadian Human Rights Act and the Criminal Code to include the phrase gender identity or expression under identifiable groups. Personally, I think including every conceivable identifiable group is ridiculous. It would just be easier to scratch all of that and add something like, no humans are exempt from these rights. All humans are recognized equally under these laws. But that would be too neat, too simple, I guess. Which brings us to the policies. Now, this is where we take ridiculousness to clusterfuckery. We're going to be going through the policies, bouncing around inside the policies, bouncing back to harassment and back into the policies and back to hate speech and back into the policies and back to the human rights tribunals and back to the policies because of how poorly written they are. They're so ill-conceived that it's made everything more confusing, and so few have examined all of it through all of these knots they've tied because of these ridiculous policies. But now we're familiar with all of the other things that make these policies the most ridiculous problems our laws have ever seen. Under the Ontario Human Rights Code, people are protected from discrimination and harassment because of gender identity and gender expression in employment, housing, facilities and services, contracts, and membership in unions, trade, or professional associations. Okay. Why not? I mean, no people should be discriminated against in these cases for whatever reason. So far, so good. And that's about the end of it. Gender identity is each person's internal and individual experience of gender. It is their sense of being a woman, a man, both, neither, or anywhere along the gender spectrum. A person's gender identity may be the same as or different from their birth-assigned sex. Birth-assigned sex is a nonsensical term. I'm not going to go into that in this video, I don't think, but that's fuckery. Gender identity is fundamentally different from a person's sexual orientation. Yeah, sure. Like, if someone identifies as a man and is gay, those two things are different whatever. Gender expression is how a person publicly presents their gender. This can include behavior and outward appearance such as dress, hair, makeup, body language, and voice. Up to this point in this section of the policy, gender expression is little more than fashion, if more than fashion at all. Oh my God, gender expression. Apparently that's part of gender expression. If I spoke like that every day, that's part of my gender? What the fuck? A person's chosen name and pronoun are also common ways of expressing gender. All of these little bits of the policy are important. They make and break connections to previously cited laws, to the human rights tribunals. This one really gets my goat. Trans or transgender is an umbrella term referring to people with diverse gender identities and expressions that differ from stereotypical gender norms. It includes, but is not limited to, people who identify as transgender, trans woman, male to female, trans man, female to male, transsexual, cross-dresser, gender non-conforming, gender variant, or gender queer. No. Trans is not an umbrella term. Trans, very specifically, comes from the term transition. It's about transitioning. For all the non-binary folk, there's a reason that trans people refer to you as trans trenders. It's because you're not transitioning. So to force yourself under this made-up umbrella that really should not be yours to decide, you're diminishing what trans people go through, what people who transition go through to become what they are. That's a really weird phrasing, I know. But cross-dresser? Really? Oh, yeah, no, this is my very first video. Cross-dresser is not a gender, it's a thing you do. It's an activity. It's not a gender. So what exactly counts as discrimination? Discrimination happens when a person experiences negative treatment or impact, intentional or not, because of their gender identity or gender expression. It can be direct and obvious or subtle and hidden, but harmful just the same. It can also happen on a bigger systemic level, such as organizational rules or policies that look neutral but end up excluding trans people. Friends, family, or others who face discrimination because of their association with a trans person are also protected. Harassment is a form of discrimination. It can include sexually explicit or other inappropriate comments, questions, jokes, name-calling, images, email, and social media. Transphobic, homophobic, or other bullying, sexual advances, touching, and other unwelcome and ongoing behavior that insults, demeans, harms, or threatens a person in some way. Assault or other violent behavior is also a criminal matter. Trans people and other persons can experience harassing behavior because of their gender identity or expression, gender-based harassment, and or their sex, sexual harassment. So we're leaping from the summary of the policies to section 7.4, gender-based harassment. Gender-based harassment can involve, and before anyone jumps on can involve, this was brought up at the Senate committee hearing by Senator McTurtlecock, to which witness at the time, D. Jordan Brown, a lawyer, responded thusly.
Let me jump in just on the legal point. After Dr. Peterson posted his videos and after he rose to the public consciousness, the Ontario Human Rights Commission deemed it fit to release a new policy document called Questions and Answers about Gender Identity and Pronouns, and in so doing, they said that refusing to refer to a trans person by their chosen name and a personal pronoun that matches their gender identity or purposely misgendering will likely be discrimination. So I think it's a little bit more certain than what you may have indicated in your comment.
So, gender-based harassment can involve refusing to refer to a person by their self-identified name and proper personal pronoun. The English language has a gender-neutral pronoun, it. Any other gender-neutral pronoun will ultimately be synonymous with the word it. And I refuse to dehumanize a person by referring to them as any word synonymous with it, no matter how much they cry, no matter how much they beg. I will never feed them after midnight. No, wait, that's not non-binary people, that's gremlins. Maybe we should look at jokes. Jokes related to a person's gender identity or expression, including those circulated in writing or by email or social media. I made a joke about gender non-conformity, non-binary people. I did it on purpose, willfully. I know exactly what I'm doing, and that's considered harassment under this law. Because I made a wisecrack. Yeah, no. We haven't impinged on free speech at all. I'm wearing a purple shirt. It's not unreasonable to expect some of my friends to crack wise about my purple shirt. If I were gender fluid, my purple shirt may be considered part of my gender expression. I have a penis and a purple shirt, therefore I am neither man nor woman, but in fact, Bananarama. And my pronouns are Bana and Rama. And the crack one makes, nice purple shirt, douchebag, is no longer just some sort of douchebag joke. It constitutes harassment, criminal harassment. The best part is, as a cis man, I'm not protected by this same law. If someone makes the exact same joke to a cis male as they would to a gender fluid Bananarama, the Bananarama gets special protection under the law. The law is no longer equally applied. Intrusive comments, questions, or insults about a person's body, physical characteristics, gender-related medical procedures, blah, blah, blah. one of the first things people attack when a cis male is particularly douchey or driving a rather large truck or expensive car is the size of their penis. Nobody gives a fuck about that. Nobody bats a goddamn eye. But when a photographer yells out at Caitlyn Jenner, "Bruce, get out your dick," or whatever the hell was yelled, there is a police investigation about it. That's not equal under the law. Absolutely not. And I'm not saying that cis males who have the size of their penis attacked should be protected by the law. I'm saying Caitlyn Jenner should man the fuck up. You know, you can't earn that many gold medals and not be tough. It's just, who the fuck do you think you're kidding, Caitlyn? The code defines harassment as engaging in a course of vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome. Harassment will have happened if the person carrying out the behavior knew or should have known it was unwelcome. If the victim says the behavior is unwelcome, then the harasser knows. If the harasser didn't know or didn't intend to harass, it is still harassment if a reasonable person would know such behavior is unwelcome. What is considered reasonable includes the perspective of trans people and other gender non-conforming individuals. A victim does not have to explicitly or directly object to harassment. They may be vulnerable and not speak out because of a threat or fear, or because the person has some power or authority over them, like a manager or landlord. Some may simply withdraw or walk away. The problem here is that the law should determine which actions are lawful and unlawful. What this has created is a situation in which the action is meaningless. The perception of the action by another person determines whether or not the action was lawful. It's made subjectivity the rule of law. It has legally enshrined what is a fact and what is real. This is beyond the realm of law. It's an egregious affront of the law against science and reason to legally decide what is the truth. Courts decide whether or not events occurred as they occurred, but they don't determine what's true. They don't determine what is a fact. That's beyond their realm. They have no business doing that. And yet here it is, enshrined in the law, that when a person says, "I am neither man nor woman but Bananarama," by law, that is true. So, between harassment law and hate propaganda laws, I could be looking at 12 years. Now, whether or not I'm convicted of a crime in a criminal court, the social justice tribunals can hold me in contempt because I will refuse to pay whatever fines they levy. I will refuse to pay any settlement they offer a complainant. Not that I have anything to pay the fine or a settlement. And were they to order some sort of sensitivity training, I would refuse to go. I would also refuse to alter my behavior. And that would be considered contempt of these extrajudicial courts that don't have to abide by what we know as the rule of law. Being held in contempt, I could be imprisoned until the contempt was purged, which, if I had any balls, would be forever. So without ever being convicted of a crime, I could be imprisoned for the rest of my life because I'm ornery. And no other reason. You still confused about the effects of C16? Capitulate or die in prison. That's the effect of C16. It's not just my silly little catch that I use at the end of my videos. We literally no longer live in a free country. We live in a country more similar to the 19-teens, 1920s Soviet Union. This is where the term politically correct originated. Was in the Soviet Union. For example, one high-ranking Soviet official says to another, "Comrade, this statement you make is not factually correct." To which he responds, "Perhaps not, comrade, but it was politically correct." That's what we've done. That's the bill we passed. We've made certain things legally true. Politically correct. It really is the People's Republic of Canada. Relevant links to shit I said in the description. Maybe. I'm Irving Twin. Like, subscribe, or don't. It's a free country. At least it used to be.